I think we're starting. So thank you, everyone, and welcome, everyone, and thank you for participating in today's webinar hosted by the National Latina Network for Healthy Families and Communities, a project of Casa Esperanza that builds bridges and connections among research, practice, and policy to advance effective responses to eliminate domestic violence and to promote healthy relationships within Latino families and communities. My name is Jose Juan Lara Jr., team member of the National Latina Network, and I'm joined by Rosie Hidalgo, Senior Public Policy Director for Casa Esperanza National Latina Network, and your host for today's part one of a two-part webinar series. This webinar series is part of Casa Esperanza's National Latina Network, Enhancing Cultural Responsiveness in the Courts training, through which we provide training and technical assistance focusing on enhancing access to justice by fostering more culturally responsive courts, court staff, and judges. Part one of this webinar series is titled Judges' Roles in Cases of Immigration, Domestic, and Sexual Violence Survivors. Before we start, just want to review a few housekeeping details. Participants have been automatically placed on mute. As an extra precaution, we ask you also do the same. If you are joining us using an agency phone and have hold music, please be aware it will be heard if you need to put the call on hold. If you have any questions, please submit them in the Ask a Question box, and we will also be providing closed captioning. This webinar will be recorded and uploaded to the National Latina Network website. Any resources mentioned will be sent to participants, including an evaluation after the webinar. We kindly ask that you complete the evaluation since this helps in shaping future content for our webinars. If you'd like to register for the next webinar in the series, you may go to www.nationallatinanetwork.org. With that, I'd like to introduce our presenters. Judge Mary Weir serves as an Associate Circuit Judge on the 16th Circuit Court of Jackson County, Missouri, appointed by Governor Jay Nixon on May 10, 2013. Prior to her appointment, Judge Weir began working in 2001 as a contract attorney with Hope House, Inc., and provided legal representation to victims of domestic violence and their children. Judge Weir also represented juveniles and their parents in cases heard before the Jackson County Family Court through her work as of counsel with the Wraith Law Firm. Judge Weir served as an Assistant Missouri Public Defender from 1998 until 2001. She was also a law clerk for the Honorable Christine Phil Rogers of Division 31 from 1995 until 1991. Judge Weir received her JD degree from Washburn University Law School in Topeka, Kansas in 1995, and also serves as National Judicial Faculty for the National Immigrant Women's Advocacy Project's NEWAP Judicial Training Network of 6 state projects providing judicial training and judge-to-judge technical assistance on the intersection of state, family, and federal immigration laws. Leslie Orloff is an adjunct professor and director of the National Immigrant Women's Advocacy Project at American University Washington College of Law. Ms. Orloff's 35-year career includes working collaboratively with experts across the country to develop and implement immigration relief, public benefit access, and family law protections for immigrant women, children, and survivors. She was involved in drafting the immigration protections in the Violence Against Women Acts 1994, 2000, 2005, and 2013, and the Trafficking Victims Protection Acts of 2000 and 2008. Ms. Orloff is a family law expert with years of litigation experience representing immigrant victims in custody, protection order, and divorce actions. She was recently appointed to the U.S. Immigration and Customs Enforcement Advisory Committee on Family Residential Centers, where she chairs the Subcommittee on Health, Mental Health, and Trauma. With that, I'd like to turn it over to Rosie Hidalgo. Rosie?
Yes, thank you, Jose Juan. And thank you all today for joining us for this important conversation. And of course, we're extremely thankful to Judge Weir for taking time from her busy schedule in the court to join us and share her insights and experience, as well as Leslie Orloff. So this is a really important topic on how do we continue to ensure access to safety and justice for all survivors, including immigrant survivors. And Congress, since the inception of VAWA, the Violence Against Women Act, since the very first time VAWA was passed in 1994, Congress recognized the importance of providing protections for immigrant victims. And in a bipartisan fashion, the first provisions of VAWA self-petition was included in VAWA. And Congress recognized that oftentimes immigrants face increased vulnerability to abuse and exploitation and didn't want the immigration system to be used to sharpen the tool of abusers. Similarly, we recognize that oftentimes immigrant survivors face increased barriers to accessing services and safety. So in each subsequent iteration of VAWA, Congress in a bipartisan manner has continued to keep these protections in place, to strengthen them, and also included some additional protections, the U visa, the T visa, when VAWA was reauthorized in 2000. So today, Leslie and Judge Weir are going to talk about these important immigration remedies as well as others and really make sure that they are part of this coordinated community response. How do we make sure that the courts, prosecutors, law enforcement, advocates, service providers, and everyone are aware of these provisions and really make sure that we can protect the access to safety and justice for immigrant survivors. Now, before we launch further into this webinar, I did want to mention that we have been receiving some TA inquiries where people are asking, what is the potential impact as VAWA is up for reauthorization now in 2018? People have been asking how that might impact the immigration remedies if there's a delay in reauthorizing VAWA. So I just want to take this moment to clarify, to make sure everyone is aware that, yes, every 5 years approximately when VAWA is up for reauthorization, what Congress really focused on is reauthorizing the VAWA grant programs that have funding tied to them and designating what the funding levels are for those grant programs. But other parts of VAWA that are changes to other parts of the statute in the U.S. Code, those provisions do not expire. They do not sunset. So, for example, housing protections for immigrant victims, the special tribal criminal jurisdiction, the non-discrimination provisions of VAWA, and immigration remedies that were enacted through VAWA. Those and other statutory provisions of VAWA are not impacted with regard to VAWA reauthorization funding levels. So those continue. So just want to make sure folks are aware of that. And we will launch now into this important webinar on the judge's role in cases of immigrant, domestic, and sexual violence survivors. So I will hand it over to Judge Weir. Thank you.
All right, well.
I'm sorry to interrupt. One quick comment. As we are proceeding, please don't hesitate to write your questions as we go along. I will be monitoring the chat box and will periodically, raise questions that we see there for either Judge Weir or for Leslie to answer. So thank you very much for making this participative and for putting any questions you have and also participating in the polls that will be coming up. Sorry, Judge, I turn it over to you now. Thank you very much.
Yeah, no problem. Well, hello. Thank you for inviting me to participate in this. It's always an honor to present with Leslie. Leslie truly is an expert. So they went through my biography already. That's where I met Leslie when I was working as a young attorney. Well, I don't know if I was that young, but as an attorney, and received training from her on immigrant issues. I represented a lot of immigrant survivors and their children when I was out in practice. And just one correction, I was a law clerk from 95 to 98. I think it said 95 through 91, and that would take me back in time, and I haven't figured out how to do that yet. So it really is an honor for me to be here and present with Leslie. She has taught me so much. I enjoy presenting with her, and I'll turn it over to her.
Welcome, everybody. I want to start by saying that this is the first part of a two-part series. The second part, which will cover protections for immigrants and domestic and sexual violence survivors under VAWA confidentiality laws, which include issues like discovery and enforcement of immigration laws at courthouses, will be addressed on October 22nd, same time, in the second part of this series. So just to get started and to get your fingers warmed up in terms of, we're going to do a number of multiple choice kind of responses. Can you check the boxes of the poll? Marissa, can you post the poll, please? And can you check the boxes as to what most closely matches your professional background or who you work for or what you do? Want to get a sense of who's on the webinar with us. It's looking like About 60% of you, at this point 57% are victim advocates. We have a few judges and court staff, some lawyers. And those of you that are writing other, can you go to the chat box and type in what you are or what you do so we have a sense of what your background is and why you might be here. Next slide, please. Or actually, there we go. So what I wanted to do is start off with a little bit about immigrant demographics to kind of put what we're going to be talking today in context. In the United States, about 13.5% of people in the U.S. are foreign-born. Almost half of them are naturalized citizens. Another third are lawful permanent residents. Those two categories of victims may have issues related to immigration status questions or immigrant-related issues, but by and large, their immigration status is secure. As to immigration status issues, the last, let's say, it looks like it's about 20% are people who are here on some kind of temporary work visa, student visa, or undocumented. And the remedies available through the Violence Against Women Act that we're going to be discussing today, and particularly U visas and SIJS that we'll be talking about in detail, are issues that, that will affect these populations in particular. Importantly, over 25% of children under the age of 18 and almost 26% of children under the age of 6 and almost 26% of children under the age of 18 have one or more immigrant parents. So many, many children in the U.S. are living in mixed immigrant status families. About 85% of families involving, immigrants are mixed immigrant status. One in four children is a child of an immigrant, and there's also over 18% of the U.S. population speak a language other than English at home, which poses challenges for language access that we're not really going to be addressing in this webinar, but both Casa de Esperanza and NewApp have lots and lots of language access materials available on those issues.
Okay, so this is Judge Weir. One of the reasons, or I guess the reason that we train on these issues with judges is that in order for us as judges to make decisions that impact or that actually are in the best interest of children and are fair to all people, we need the knowledge. We need to understand the impact of immigration relief before we can enter orders that truly do reflect people being able to access justice and reflect that we have considered all aspects of the best interest of children. So I think somebody, there we go.
I can change the slide.
I don't know if we're going to ask this as a question, Leslie, or just put that out there for people to think about.
Well, I would say, Judge Weir, what has been your experience on what you've seen in the courts on this? And those of you that are in the on the webinar, use the chat box to share what your experiences have been while Judge Weir is sharing hers.
Well, I think my experience on the bench is I often see lawyers raise immigration issues as a sword to try to say, well, this person's not documented, and therefore children should be placed with the other parent if they happen to be with a U.S. citizen or a lawful permanent resident if they happen to be partnered with them. And so I think there's a lot of misinformation that gets put out there, and I think that what I've seen is with the trainings that we've been doing is, and the more that judges are educated, we are really able to recognize, that's a red herring. It doesn't affect their rights in this court. My role, again, is to go back to best interests of children. My role is to provide everybody with access to justice. And so I think, and I saw this when I was an attorney representing victims also, when the judges didn't understand either their role or the rights of immigrant victims and children, there's a lot of confusion. So the more educated the courts are, the better decision making we can engage in. So this slide will show you the purpose of immigration relief for survivors. Obviously, it improves access to justice. We all believe in access to justice, but if you are an immigrant and you are afraid to come forward to the court, or you're afraid to call the police because people out there are not educated as to what's going on, then we're really not. We really aren't opening up. It's not justice for all. So by educating folks, be it our community, our police in the community, by building relationships, people are coming forward. We're seeing more prosecution of perpetrators when immigrant victims are willing to come forward and feel safe in the courts and understand that, the judges aren't, our role, I'm not an immigration court, so I don't issue orders to deport people. And I think there's a lot of confusion about the different roles of the courts. And so I think what we're seeing, hopefully, and hopefully you're seeing this in your communities, is more victims coming forward to report crimes and accessing different options for themselves and their families. And overall, the goal is to keep our community safe. And we're safe when people report people who are victims of a crime, be they an immigrant or be they a non-immigrant. We want people reporting crimes. We don't want victims hiding in the shadows. So again, what's the benefit then? Well, we want people working. We want them working legally. We want people who have a right to be protected from deportation. We want them to be able to exercise that right. We don't want people driving around without driver's licenses. We want people driving legally, operating in on the roads. The ability to access Social Security numbers comes with immigration status. We don't want people to be homeless if we can help that. We want people to obtain access to housing and services. We don't want people, as I stated earlier, we don't want people hiding in the shadows. So we want people to come out of the isolation and work in the community, work with service agencies, access the courts, contact the police, and of course we want people to be able to travel like everyone else to and from the United States and get on a lawful path to residency and citizenship.
And what I think, this is Leslie Roth, that is really important about what Judge Weir is saying is that for immigrant survivors, one of the things that we know is that generally their willingness to use the courts, what research has told us, is that they go to advocates and attorneys, and it's the advocates and attorneys that bring victims to the justice system, and that need to develop relationships with their courts, their local courts, so that they can feel comfortable with answering victims' questions so that they can overcome some of the victims' fears and barriers and get them to be willing to seek a protection order, to seek custody of their children and the like. And so one of the things we've developed as a tool, because also immigrant victims there are many services that are available to everyone without regard to immigration status, and it's important for courts and their victim advocates and attorneys to be able to easily find out which victim qualifies for which forms of benefits. Judges don't want to be in a position of ordering people to go get access or go file for a benefit that immigrant family or their child aren't eligible for. They don't want to set people up for failure. They want to set things in place that will support children and good outcomes for that family. And so we have a tool that we're just launching where you can look up the public benefit. This is a child care example. And you can look up your state, and it'll explain which immigrants have access to which benefits in your state. We also have state-by-state charts with that level of detail. So what's really important to understand when you're working with immigrant victims, and Judge Weir alluded to this earlier, is there's a dynamic of immigration-related abuse that comes into play in addition to what domestic violence survivors or sexual assault survivors experience generally who are not immigrants. And it includes when abuser has power and control over the immigration papers of his spouse or children. It also, an employer may have it over a worker. And there's various different kinds of immigration-related abuse and threats. And what we found is in the domestic violence context that where a perpetrator of domestic violence is a U.S. citizen or lawful permanent resident, and they can control whether or not to file papers on their children or the spouse's behalf, perpetrators of domestic violence often don't file, and that enhanced power and control leads to higher rates of domestic violence experienced by immigrant children and spouses, particularly those when the perpetrator is a U.S. citizen, spouse, or parent. And that when the perpetrator can file papers, almost 3/4 of the time he never files, and when he files, there's a mean delay of 4 years. And I'm using he here very importantly. It's important to note that the violence against women immigration provisions that protect victims are gender neutral. I'm using he because perpetrators are most often the males and the victims are most often females, but there are cases where it is the other way around. The other thing that's important to note is that this immigration-related abuse coexists and provides evidence in a particular case where it's going on that physical and sexual abuse also are occurring in that relationship, or it predicts that relationship, the violence in that relationship is escalating to include physical and sexual abuse. And so to address this, the Violence Against Women Act, as you heard Rosie in her introduction talk about, created protections for immigrant victims that, and the goal was to both protect victims and improve community policing. And I'm just going to tell you one very brief story. We were doing a training outside a major metropolitan area once of law enforcement. And there was an officer in plainclothes sitting in the back of the room who was leaning back on his seat with his feet out. And we weren't sure he was paying attention to the description of what was going on at all in that training. And at the end of the day, we asked, has anybody has an example of using the U-visa in a case? And he raised his hand and he said, the U-visa saved mine and my partner's life. And that's because he was embedded in a gang, in a very dangerous gang in that area. He was undercover. And it turned out that one of the gang members, this lead gang member's girlfriend, was a victim of domestic violence who'd found her way to the U-visa certifier in her community and was pursuing a U-visa and trusted that and built a relationship of trust with that law enforcement officer. One day she hears that they like, yes?
Can I interrupt? I'm sorry. Yes. I can't even believe this is happening, but they are evacuating my office, the courthouse. And there's fire trucks out front. I just checked to see if it was a drill or that I could stay through, and they're telling me I have to get out of the building.
Okay.
I don't know if it's a bomb threat or if it's something else, but I can't believe it. I'm so sorry.
No problem. Can you leave your line open in case it's a fake and you can come back and join? And if not, I will do my best to cover for you.
Absolutely. I'm just going to leave it as is, and I will try to find somebody else who can tell me whether I can get right back up here, okay? I apologize to all of you.
Okay. Thank
you. No problem, Judge Weir. Be safe, and if you're able to join us again, we would appreciate that.
All right.
No. Okay.
Thank you.
So I will end the story quickly. She told the U-Visa certifier that they'd identify the undercover police officers, and they pulled them out of the gang and saved their lives. So the U-Visa as a tool goes well beyond it creates a pattern by which victims continue coming forward, and that's part of what we had hoped to achieve in the Violence Against Women Act. There's a range of forms of immigration relief that are available to immigrant crime victims. We're not going to go into great detail on all of these. We're going to focus a bit more on the U-Visa and SIJS, Special Immigrant Juvenile Status today. But this is a tool that you can hand out at your courthouses together with a Department of Homeland Security brochure that provides know your rights information that should be available to crime victims who may appear at court who may be immigrants. And it's a very, very good tool. So I'm going to briefly go through some of the major forms of relief that are available to immigrant victims so that you're aware of them and you may be able to spot those cases, who's eligible in the cases that you're working on, whether you're a judge, a victim advocate, or an attorney. So there's something called VAWA self-petitioning, which is available to, it's there to protect people who are abused by their U.S. citizen or lawful permanent resident, spouse or parent or step-parent, or they're abused by their over 21-year-old U.S. citizen son or daughter. These are very common cases. These are cases that, protection order findings, for example, by courts can be very helpful in documenting the abuse, as can, findings or conclusions of criminal court cases. And that victims, and it can be important for courts to include court orders when they are working on a case where victims are married to make findings that there was, in fact, a marriage can be useful in the victim's ability to prove good faith marriage in the VAWA self-petitioning cases. It's important to note that for VAWA self-petitioning and for the U-Visa, which I'll be talking about in a moment, that there are forms that the definition of domestic violence in immigration law is broader than every state protection order statute. So if under your state law, or state either protection order law or criminal law, if the abuse that occurred would be considered domestic violence, then it is absolutely sufficient for both VAWA self-petitioning and for the U-Visa case. But it's important to note that making findings about forms of emotional abuse, intimidation, sexual abuse, coercion, and things like that, victims in court orders can assist victims filing for a VAWA self-petition because they don't have to wait until the first beating before they're eligible for immigration relief. And so the next form of relief that Congress created in 2000 is called the U-Visa, and that is broader. So the VAWA self-petition helped immigrant victims of domestic violence, child abuse, and elder abuse. And that's intimate partner or spouse abuse. The U-Visa is broader. It helps all of the other immigrant victims of domestic violence who may not be married or whose abuser may not be a U.S. citizen or lawful permanent resident, but it also helps people of other kinds of criminal activity. I'll show you the list in a minute. To qualify, somebody has to be a victim of criminal activity. They have to have been or being or likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing of that case, and those are all ORs. Here, they have to show substantial physical or mental abuse as a result of the victimization, so there's a higher level of crime victimization or proof of the harm that has to be shown here compared to VAWA self-petitioning. And the crime has to have occurred in the U.S. or violated U.S. law. U-Visa criminal activity could have occurred abroad. Or VAWA self-petitioning, sorry, criminal activity could have occurred abroad. The next form of relief that and so we're going to be talking more in a few minutes about U-Visa certification, particularly by judges. The next form of relief is something called Special Immigrant Juvenile Status. It's available for it's a form of immigration relief for unmarried children under the age of the majority under state law who are victims of abuse, abandonment, or neglect. It would cover children in a dependency, a delinquency, a child welfare proceeding, but also custody, protection order, and divorce. The abuse would have had to occur by one parent, and it could have occurred anywhere in the world. So children who come before the courts who suffer, let's say, child abuse in addition to their mother's domestic violence, where it occurred in your community and the mother is coming to seek protection order. If the child is also abused and the abuse occurred in the United States, that child could be as eligible for Special Immigrant Juvenile Status as the children who may come before the court seeking that status where the abuse occurred abroad. But that in the U visa context, they have to provide, in order to file, they have to provide a certification or basically required findings from a state court. We'll go over that in more detail. It's a prerequisite to filing, just as the U visa has a prerequisite to filing, which is called a certification, and we'll talk about that more. So for those of you on the call, we're going to do another poll, and I want to know what % of your cases involving immigrant victims is there co-occurring abuse where a mother is suffering domestic violence and the child is also abused by the same perpetrator. Can you place the poll, please?
Leslie, I'm back in.
Yay!
Sorry about that.
Okay, wonderful. So we're taking a poll right now on who has seen people where there's overlaps between co-occurrence of domestic violence and child abuse. And we're seeing that almost 50% of you, or no, 27% of you are saying that in over half your cases you see this overlap, and another 50%, more than 50%, almost 60% of you are seeing it between 26 and 50% of the time. So you're seeing high rates of overlap. So it's important to note, because these will be cases where there are differing immigration remedies and more immigration remedies available for the mother and the child, because an abused child can include their mother in an immigration application, and an abused mother can include her child in the immigration application. So there are various ways, options available to these families. Thank you for the poll.
And I just want to add in there that, I talked a lot about the importance of education, and a lot of our judges they really don't know about these remedies. They don't know about the U visa or the Special Immigrant Juvenile Status or the T visa, which I know we're going to get to, some of these other remedies. But when they do learn about these, it's really, I've gotten calls from friends who are on the bench who are just like, hey, I got to use my knowledge on this U visa thing. Hey, I got to do SIJS findings. So it's important, if there are lawyers in here, to make sure you're asking the court for the relief. Because judges are becoming more knowledgeable, and if they don't know what you're talking about, then take the time to explain it to them.
And we can provide you materials and support should that happen through technical assistance. Okay, so another form of relief that is available is the T visa for trafficking victims. It's a severe form of victims of severe forms of human trafficking and persons. It's either sex or labor trafficking involving a victim under the age of 18 or an adult who is subject to force, fraud, or coercion. There's an overlap with these trafficking victim cases, and trafficking is also one of the forms of harm that would be the basis for a U visa. One big difference between the T visa and the U visa is that the T visa brings many more access to public benefits and support from the public benefit safety net than the U visa does. And some examples for those of you that do domestic violence work, and both courts may see this and lawyers may see this, typical examples of domestic violence or sexual violence cases where a victim may also qualify for a T visa would be when a domestic violence victim is required to work outside the home and hand over her wages to her partner. That also happens when she's working, let's say, for his family business and never paid. People may be required to do housework or sex or not get in, and in order to maintain housing or financial support. So if he uses that kind of coercion in a relationship, it might be able to be a trafficking case. Sometimes you'll also have the case where the trafficker is also her partner, and you could have domestic violence where the perpetrator is her trafficker and her partner. And so what's important to understand, let me start with the victim advocate part, and then I'll turn it over to Judge Weir to talk about the court part here. But for victim advocates and attorneys on the call, it's really key to provide support so that victims can safely access family court and the criminal court cases. We know that without support from victim advocates and attorneys, it's very hard for limited English proficient and immigrant victims to use the justice system. And that the earlier the immigration case is filed, as we'll be talking about on the next webinar, the more protection from deportation sooner the victim gets. Judge Weir?
Yeah, and it's important when we look at other areas of family law or housing, tenants' rights, and things like that, criminal defendants, we refer people. We want them to have lawyers so that their rights are protected. Well, I think it's important also for judges and the courts to do this. And so it's important when we see somebody that may have an immigration issue, to refer them to either an appropriate agency that is working in the area that can then connect them with an immigration attorney to explain their rights, or refer them to an agency that can provide their family services. And that's no different than the other referrals that we're doing to people, to legal aid societies and things like that, to help them in cases. Again, knowledge is important for everyone, for our courts, but it's important also that the people appearing in front of us understand their rights. And while we may not be able to sit there on the bench and explain their rights, we certainly can refer them to appropriate attorneys and agencies that can help them, so that, again, it all goes back to access to justice. So it really is meaningful.
And so what's important, if I may, that I just put in the chat box a link to the directory. We have a directory of programs and services that have experience and expertise serving immigrant victims in all states that can help you find programs like those in your community. Judge Weir?
Yeah, and so these are some of the materials on the slide that are excellent to make sure are in your courthouse for distribution. Whether you're putting these up in, down in, we call it adult abuse, where folks are coming in to file for orders of protection, just different areas where folks are accessing the courthouse. Make sure your prosecutor's offices have these types of things available and posted also. Or you can't make them, but you certainly can encourage them. So throughout your courthouse that these things are available, and brochures from local agencies that are out there.
So it's really a planning for those victim advocates and attorneys on the call to do safety planning. You want to try to get the immigration case, if you can safely do it, filed before the family law case, because that way, when the perpetrator receives notice, a service of process and the protection order or the custody of the divorce case, and they try to call in retaliation to turn the victim in so that they can gain an advantage in the custody case, the case will be logged in the immigration system, and that filing early can help protect them. Victims should carry copies of their immigration case number, their A number, with them at all times so they can explain, and as well as copies of any protection order they receive so they can explain if they're stopped that they are in the process of filing or they've already filed an immigration case and they have a protection order and that they're a victim. There was a new notice to appear policy that was issued by the Immigration and Customs Enforcement in June 2018, which said that essentially any immigration relief denied on its merits, an application denied on its merits would be turned over for removal. That policy was implemented on October 1 but on September 26th, United States Citizenship and Immigration Status confirmed, confirmed that for now, these provisions are not going to be implemented as to humanitarian cases and employment cases, and that includes VAWA, T, and U visa cases. We're recommending that it is a good practice to screen all battered immigrants applying for VAWA, T, and U for 10-year cancellation or VAWA cancellation, and to file strong, well-documented cases that victim advocates can play a huge role in helping lawyers develop. So what we're going to do now is I'm going to, Judge Weir, shall I read the scenario and then, or summarize it, and then you can ask people the questions?
Sure.
You want to handle it that way?
Sure.
Okay, so we're going to give you a little scenario to kind of get you to see how this may appear in your cases. And I'm going to kind of summarize this. So Clara met Eduardo, who was a U.S. citizen. He'd been at home visiting her in El Salvador, in the community that she lived in. Clara had a child, Miguel, who was 9 years old by another relationship. Clara and Eduardo ended up, Clara got pregnant. She had a child, Lupe. And after the child was born, Eduardo brought Clara, Miguel, and Lupe to the U.S. to live with him. When they arrived, Eduardo took Clara, Miguel, and Lupe's passports and became physically and sexually abusive of Clara and abusive of Miguel when he tried to intervene to protect his mother against Eduardo's abuse. And then Eduardo would also physically beat Lupe when she misbehaved. Within a year following their arrival in the U.S., Eduardo forced Clara and Miguel to begin working for his family business and never paid him for their labor. One night when Miguel was 13 and Lupe was 5, Eduardo's rage led to severe beatings with the belt of Miguel and Lupe. Clara tried to intervene to protect the children. Eduardo strangled her until she passed out. Neighbors called the police for help, and Clara talked to the police when they arrived. They arrested Eduardo for attempted murder and child abuse and took Clara to the hospital and placed the children in the care of the state.
All right, so what we want to do then is, with that scenario, what kind of immigration relief do you think Clara would qualify for? Can they register to vote on this? Do folks think Clara would qualify for the U visa, for VAWA self-petition as a parent of Lupe, for a T visa, none, or all of the above? And let's walk through it then. So a U visa, would Clara qualify as a victim of a crime?
It looks like 85% of the people are saying she definitely qualified for a U visa, which is true, as a crime victim. And and they are also saying she would qualify for a VAWA self-petition as a parent of Lupe. What happens there is, if she were married to Eduardo, then she'd qualify for a VAWA self-petition as the wife of a U.S. citizen. But as the girlfriend of a U.S. citizen and the mother of his child, she doesn't qualify. But since Lupe was abused, Lupe could include her mother in her own self-petition. And T visa, Judge Weir, do you want to talk about that, or do you want me to?
Go ahead.
Okay, so T visa, the qualification would come from forcing Clara and Miguel to work in the family business and not paying them. So yes, the correct answer on this one is all of the above. Next.
All right, so then what we're looking for then is what forms of immigration relief would Lupe and Miguel qualify for? So Lupe is the child of Eduardo and Clara, and Miguel is the child of Clara, who came to the United States with her. So do we think they can both VAWA self-petition, both qualify for a U visa, Lupe qualify for a T visa, or all of the above?
This one's a little trickier. It looks like half of you are getting it right. Both children qualify for a U visa. That's the correct answer. Lupe also qualifies for a VAWA self-petition, but Miguel does not. Miguel qualifies for a T visa because of the forced labor. Lupe does not.
And Miguel does not qualify for the VAWA self-petition because he is not the child of Eduardo. Is that correct?
That's correct.
All right.
Okay, so we got a feel for that. Good. Thank you, Marissa. Okay. So now we're going to do you have your true or false or yes, true, false, or yes, no question, Marissa? Marissa? Okay, so just type in the box. Oh, here it comes. Okay. So we're going to put up a true, false poll. And the question here is, do both Lupe and Miguel, so the question, let me do it this way. Is it true or false? Both Lupe and Miguel qualify for special immigrant status. Is that true or false? 6 of you think it's true. I'm assuming the rest of you don't know or want to know. A couple of you think it's false. That number's growing, about 20%. The answer is false. And it's false because, again, Lupe qualifies for special immigrant juvenile status because she suffered abuse by her father. Miguel, because Lupe and because Eduardo and Clara are not married, then Miguel would not qualify for special immigrant juvenile status. If Lupe and Eduardo were married, then he could qualify for special immigrant juvenile status as the stepchild of the perpetrator, Eduardo. Great. Me or you? So now what we're going to do is talk about some family. We're going to conclude the rest of the 40 minutes we have together talking about some issues that arise in family court cases, SIJS, and U visas particularly. So what we're going to do is start with the impact of divorce. So for those of you that are hearing divorce cases or that are bringing cases in divorce, it's really important to understand that divorce isn't benign when it comes to immigrant families. That divorce can trigger a 2-year filing deadline in VAWA self-petitioner cases. Divorce can end the legal access to legal status in the United States for spouses and children of people on work visas or student visas or diplomatic visas. And divorce can cut off access to lawful permanent residency for asylees as well. So it's something you should be aware of. If somebody's trying to come in and get a quick divorce, there may be something going on behind that. We have a bench card we're developing on divorce, and we have some training materials on divorce if you're running into these issues in the meantime. We hope the bench card will be done in a month or so. The other thing that happens is people will walk in and try to get annulment instead of divorce. So you'll see these odd cases where they've been married 10 years, they have 5 children, and somebody comes in and asks for annulment. And they're not Catholic. They're not doing it for religious reasons. There's no evidence of that. And so basically what's important to understand is that annulment, if you do an annulment instead of divorce, when it would normally be a divorce under any other circumstances, your ruling could set up the immigrant spouse for marriage fraud, criminal charges under immigration law potentially. And so you want to avoid that. And it also impacts spousal support and property division. So the last thing, as we move into issues of custody, what's important to understand is we saw earlier in your poll today that immigrant victims, that there's, one of the things we've seen research happen is that where there's an intersection between where there's an overlap between spouse abuse and child abuse, that co-occurrence drops dramatically in immigrant families when the immigrant victim, with support of an advocate or attorney, begins accessing justice, whether it's protection orders or custody proceedings or immigration relief. That it really does make a difference for immigrant children when their mothers start seeking help.
All right, so we often see that the issue of immigration is brought up in family court. Often, as I stated earlier, I used to see it a lot being raised as a sword and not a shield, and meaning that it was often used to say to the court, well, Your Honor, she's an illegal immigrant, she can't be here, he's got to have custody of the children, regardless whatever else has happened in the family. So what we've seen is the issue is not, it is relevant to the court. When you're looking at issues that are common, such as immigration abuse, where the perpetrator is not filing or withdrawing immigration papers, that he or she has threatened to turn the other party in for deportation. Go ahead, call the police. If you say anything, you're going to be deported. Or if you tell anybody, I'm going to have you deported. It is something that is part of the history of violence, immigration-related abuse. These types of threats are very common in a very common dynamic when you're dealing with immigrant victims and survivors. So it's an important thing for the court to understand. But what it's not relevant to making a best interest of the child determination, evaluating the parenting skills, whether one person is documented or not. It's not really relevant to who's going to be the primary caretaker determination, or to the requirements of awarding custody to non-abusive parents. So again, I always use that, it's a shield. It should be used as a shield, not a sword. We don't take children away from their we shouldn't take children away from their parents simply because they're not documented. That is not a factor in any state that I know of as best interest determinative factors when you're dealing with child custody.
We have some tools for you on these issues that we have training materials, and we'll put the link up in a minute. We have a manual for judges on special immigrant juvenile status that has all the state best interest factors and a map where you can see how the states compare and how state laws compare. It's very, very useful on this topic. Did you want to address this, Judge Ware? Okay. So, and we just have for you also, there were findings by the ABA that were super important and very helpful in clarifying why it's important and how children are harmed when the judicial system gets misguided by a party trying to use immigration status against the opposing party.
Yeah, and this is really important because the number one protective factor for children is placing them with the non-abusive parent, and that's the experts. That's not Judge Weir saying that. That's things that have been said by the experts on child development for years now. So these things are out there. The AB Center on Children in the Law, and these are part of things that we're providing to judges. But it's important for lawyers to make sure that this information is getting to the courts. We're doing trainings, working with Leslie throughout the country, but we're not in every state, at least not yet. And the bench book is out there, and again, best interest. Encourage the courts not to be, taken down the wrong path here. These are the ABA Center on Children in the Law. Those things are important to get before the courts so that, we can review these, we can understand, stay on the right path, follow the statute, don't veer off, don't get taken down the wrong path.
And so what's important to understand is that sometimes you have a parent who has a criminal history, or you have a parent who has an outstanding order of removal. Those are the people that are most likely to get removed. On the other hand, when you have a victim, and you're going to be, as a judge, making a finding of domestic violence, sexual assault, human trafficking, child abuse, many, many times harking back to what we discussed earlier, those victims will qualify for immigration relief, but they may not know it until they find the Know Your Rights materials in your courthouse, or they get to a victim advocate or attorney who can explain it to them. So it's important to understand there's a lot of misinformation out there about who is likely to be removed and who is not. This is the current enforcement priorities, and as you'll see, it's very criminal law focused, focused on criminal convictions, open criminal cases, and people with removal orders, again, that have removal orders against them. And this is the data from both 2017 and 2013 that shows the actual removals also are focused in those same general areas. So when you're talking about that it's important when you're thinking about custody cases to keep that in mind as a judge and as a lawyer litigating these cases. And Judge Weir, back to you on the myths and facts.
Yeah, and I just want to say something before that. One area that I always warn people to, there used to be somebody comes into the courthouse and files for an order of protection, and then the other party runs out, gets served, and runs and files, and everybody says, well, we'll just agree everybody's going to have an order against them. I really encourage people to be very careful with that, because if a victim has an order of protection against him or her and winds up with a criminal charge because they get tricked into violating that order, or they violate the order, could be a deportable offense. Correct, Leslie?
Absolutely. And so there's some real dangers to victims to agreeing to protection orders against them. It puts them one step away, from removal. So finding a violation of a protection order leads to deportation. Issuance of a protection order does not, but it's very dangerous for victims to end up with protection orders issued against them if they're immigrants. So the last thing on custody I think we want to address.
I'm sorry, there you go, the myths. All right. So, this is what we often hear in the courtroom. Your Honor, she's going to be deported. She'll probably be deported tomorrow. Is that true? Probably not. The fact is there are many policies out there that prevent the detention or the removal of immigrant parents who are crime victims. And that often, we do hear this a lot, that the parent is going to flee. They're not a United States citizen. They're going to take the child. You need to give my client the child. And it may be that a judge makes a decision to give the abuser the child, to place custody there. But it shouldn't be for the reason generally that unless there's further evidence to show that the parent really is a flight risk. What we find is that it's the U.S. citizens and the lawful permanent residents that are more likely to flee with children, especially when there have been threats of kidnapping the children, or they're dual nationals, or they're the ones that are are able to freely travel to and from the United States. The parent has no livelihood is often raised. Your Honor, she can't support the children. He can support the children. The children have a path to immigration relief. Not the children. The survivor or the victim has a path to immigration relief, work authorization, and benefits. And then we often hear...
As you can order child support, correct?
I'm sorry, and child support, yes. Both parents have a responsibility to support the children, and if one parent has been the provider for the children, we're not going to just turn around and say, well, if I place the children in the undocumented parent's custody, well, I'm going to order child support too. So there's a responsibility there for the parents, and it's important for courts to make those child support orders. Or there's the myth that a legally present parent must have custody in order to file for benefits for the child. We often hear that raised in court, and that is not true. It does not affect the parent's ability to file or gain immigration benefits for the children.
Right, so you don't have, a parent doesn't have to have custody in order to be able to file for their child. So this is a very good case. It has good law that basically says that the constitutional right to a custody of a child absent unfitness applies to undocumented, detained, and deported parents, not just parents, so that those being undocumented, detained, or deported shouldn't affect your ability to have custody and control of your children. There's a really good directive that gives details about how to get children to parents who are detained to court to participate in proceedings involving their children. And on the protection order front, it's really important to note, additionally to what we discussed a moment ago, that there are very good creative remedies that protection orders can provide to immigrant victims, including stopping immigration-related abuse, protecting them when they're still living with their abusers. We call them many victims stay with their abusers even though they file for immigration relief until they get that immigration relief to a point where they receive work authorization. So it's important to think about getting and continue to get protection orders for victims that just say do not molest, assault, threaten, or abuse for victims who are not now choosing to leave their abusers. They can be used to obtain documents needed for immigration cases, make findings about the age of a child, for example, the existence of a marriage, findings about parent-child relationships, and can be used in very other ways that are very helpful to victims. So now we're going to turn to U-Visa certification by judges.
Okay. Did you want me to pop in here?
All yours.
Okay. So this is an area where I think we see more familiarity by judges with the their role in U-Visa certification, and basically a U-Visa, it's not this. The judges get confused when we talk to them about this at times. Judges aren't creating an order. A certification form is provided to the judge by a lawyer or somebody who's working with a U-Visa applicant. And what the judge has to look for is the person a victim of a qualifying activity? And we've got a list below that'll go through qualifying activities. Did the qualifying activity occur in the United States or violated U.S. law? Did the victim possess, or does the victim possess information about that crime? Has that person been willing, or are they likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing of the offense? And has the victim suffered substantial physical or mental abuse as a result of the victimization? And I'll tell you where we see a lot of these are in order of protection cases. So an order of protection is over. The victim came to court, swore out an affidavit to obtain an ex parte order, came back to court, raised their hand, testified to the court that the allegations in the petition were true. That is enough of being helpful because they're reporting to you or to the court that what occurred to them, and you're making a determination. Well, this person was assaulted. That is one of the qualifying activities. And so the judge is able to sign a U-Visa certification. And so one place where courts tend to get hung up on these types of things is we are not, by signing that certification, we're really being, when I look at that form, I'm looking at it really as a fact. What are the facts here? What occurred? On October 15th, this person came to my court. They raised their hand. They testified I gave them a full order of protection based on the following allegations or the following testimony that occurred, that they were beaten or sexually abused, one of the qualifying criminal activities. Just because I signed that form, I am not granting them immigration relief. State court judges do not have the power to do that. The U visa certification is just one step in the process of for someone who is applying for a U visa. That certification needs to be signed. It also can be signed by prosecutors. It can be signed by police officers. But as we often know, a lot of times these cases don't get prosecuted because the perpetrator has fled. They can't find them. So they often will have to come to the court. So that's where we're seeing those types of cases. These are the qualifying criminal activity. One of the things that's important here is what you do see here is domestic violence. That's the first one up there. It doesn't say assault and it doesn't say battery, but it does say domestic violence. So you go to your state law, and in my state, the state of Missouri, domestic violence includes assault, battery, harassment, sexual assault, false imprisonment, coercion. So what you want to make sure that the courts understand is that they're relying on their own state law.
Yeah, and what's also important, that's absolutely true, and it's also important to understand that when you're talking about a judicial certification, judges will always be signing based on their state law and the protection order or the findings they made. In a custody case, they may make findings of extreme cruelty that might be useful in also proving domestic violence for U visa purposes, but it's generally, going to be that state law definition. And it also includes attempts, conspiracy, and solicitation to do those acts as well. Judge Weir?
Okay, so what you're seeing here is the majority of U visa criminal activities really encompass domestic violence and sexual assault, either rape, incest, human trafficking, or so that really is the majority that we're seeing.
So Judge Weir, I want to answer one of the questions in the chat that came up, which is, it says that protection order hearing does not make the victim helpful or likely to be helpful in an investigation or prosecution. How is it, basically, that then you can certify? And so that was a question that the Department of Homeland Security addressed in their 2011 publication for judges, courts, and prosecutors, their resource guide on U visas. And what they've said is because the statute makes judges certifiers, they recognize that there are context and that the regulations and the statute, the legislative history of the statute that was written into the statute in 2000 say that a victim has to be helpful in either the detection, investigation, prosecution, conviction, or sentencing of one of these crimes. And they're all ors. So that DHS has interpreted the law by regulation to mean that a judge in a protection order proceeding or in a custody proceeding where there may never be a criminal case is detecting and making findings about domestic violence or sexual assault or trafficking or one of these criminal activities that is absolutely independently sufficient for the issuance of a U visa on behalf of a victim's behalf, even if there were never any calls to the police, and that has been the law since 2000. Judge Weir? I think I actually answered the next question, so we'll skip it. So just to reinforce that victims will come to the court to seek U visa certification when maybe their only contact with the courts was a protection order, or employment, or a welfare case. They may have called the police for help and the police didn't get an interpreter, so they couldn't communicate. Is another reason why you might end up with a judge for certification as opposed to law enforcement. And the judge in a criminal case could observe the attendance and the participation of a victim showing up for hearings even if they don't testify.
Yeah, and just to be clear also on that last, the last question, I make sure that if I'm doing a certification that when I'm filling that out, that they recognize this is a restraining order hearing. So it is what they came and testified at. You know, I'm not saying it's a criminal hearing. I'm not going that far. It is DHS's interpretation that amounts to helpful in detecting criminal activity. So they allow that interpretation. So.
But thank you for the question. That's a good question.
Yeah.
Judge Ware, back to you.
So where are we here? Okay, so again, you know, one of the concerns for the courts is, you know, we're not supposed to vouch for people, and so we really want to point out that the certification tells immigration three things: that we believe the applicant is a victim of a qualifying criminal activity, that they had knowledge of that criminal activity, and they were or they are likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing. When I have filled out that form, I said they were helpful in the detection by coming to my court, an order of protection court, raising their hand under oath and testifying as to the allegations that amount to a qualifying criminal activity. So sometimes I will attach the petition that was also filed, and then I go into the orders that I entered based on that testimony or evidence that was presented. If there were photos, if there were witnesses, I go into that. So,
Judge Ware, I have a question. So
yeah.
that you could do the same thing. Let's say a victim in her affidavit, when she files for the protection order, talks about allegations of abuse that have occurred. She serves the perpetrator. He doesn't show up. So you're going to take information from her and do a default protection order, or he shows up and consents. You can certify in both those instances as well. Isn't that true?
That is true. And, you know, I make it quite clear who showed up, who didn't. But somebody was under oath, and they were under oath, they raised their hand, they testified to this, and then, again, any other evidence that was presented to me. I mean, if I just make a record of it. But, yes, again, I just give the information as a fact. These are the facts. This is what occurred in front of me. And these are the findings that I made. What DHS does with that certification is up to them, but it's my understanding they do find that they will proceed on that type of a certification.
Absolutely. So just to quickly kind of begin to conclude on the U visa and then shift over to some time for SIJS, but that basically as the Judge Weir said, what happens in the courtroom protection order court is sufficient. You can get help. The victim can have been helpful by getting a protection order, calling police. But then what happens to the criminal case after she's made her report or whatever isn't what result. She can get help. She can meet her helpfulness requirement even if the case isn't going forward for various reasons. There's a wide range of types of cases in the civil court context and the civil and criminal and family and juvenile context where judges could hear evidence that would be sufficient to issue a U visa certification. And Judge Weir, I'll turn this back to you.
Okay, so again, these are just examples of helpfulness that they filed, and they appeared at a hearing for a full order of protection, that they pled and or testified about the abuse or the sexual assault in a court case. Again, I've seen them primarily in the civil area in certifications come from protection orders. I've seen a few come from a divorce case, mostly in protection orders, but you know, there are numerous ways you can see them. We've had, you know, small claims court, housing, cases where a victim is has been brought before the court because the perpetrator keeps coming and assaulting her, and they turn around, they file a landlord-tenant case, which they're not technically supposed to do, to remove her based solely on his behavior towards her. So, I mean, there's different areas where you could see this. And there's evidence that the victim called the police, made a police report, cooperated in a criminal investigation. I'm not as familiar with the EEOC investigations as Leslie would be.
But that can be sufficient too. Just like with a protection order, if they went to the EEOC, came forward about, let's say, sexual assault in the workplace, that the EEOC is moving its case forward, that can be sufficient for certification as well. And here's some of the criminal things that you typically think of that a judge might observe in a criminal proceeding that would lead a criminal court judge to certify. And in terms of U visas, it's very important to note that there's only 10,000 a year. It takes about 4 years to get access to work authorization and can take 11 years after that before the victim actually receives the visa. But there's some protections against deportation that happen with filing, and the U visa ultimately can lead to lawful permanent residency. Last point on the U visa form for judges. Judge Weir?
Okay, and one of the issues is this form is relatively, well, it's been amended because many of us weren't comfortable with how the old form looked. So it's important to know that you can go in and you can amend this, and you can write in based on what I did. These are my findings of fact in an order of protection or in a divorce or in a child abuse and neglect case. That, and then just remember that you believe what you're certifying is that you believe the applicant was the victim of a qualifying crime. The only thing the certification does, it does not, again, it does not grant anybody citizenship or lawful permanent residency. It is evidence to DHS that DHS then uses along with a whole lot of other materials to decide whether that victim is going to be granted immigration relief. It's just one piece of that puzzle.
Okay, so for the last 10 minutes of the webinar, we're going to focus now on closing out around some of the details of special immigrant juvenile status for immigrant children who are victims of abuse, abandonment, and neglect. This was a form of humanitarian relief for immigrant children that were abused, abandoned, or neglected by at least one of their parents that's been around since 1990. Congress explicitly included a role for state court judges because state court judges are experts in deciding child's best interest, deciding who gets custody of children, and it's kind of an inherent part of what the kind of court decision making that judges do, adjudicating facts of abuse, abandonment, or neglect that occur to children, and issuing custody orders in protection order, divorce, custody, all kinds of cases. And so, and what's important to understand is the reason immigrant children have to come to state courts is because as a matter of federal law, they must get an order from a state court judge making certain findings in order for the child to be able to file for special immigrant juvenile status. And just as Judge Weir was talking about in the U visa context, these state court orders are evidence. They don't grant special immigrant juvenile status to the child. Only the Department of Homeland Security can do that. Mary? Judge Weir?
Okay. Again, when a court is looking at possibly making special immigrant juvenile status findings, you need to make sure that they're going back to their state law. So, does the court have jurisdiction to issue orders regarding the care, custody, or placement of an immigrant child? Okay, with an individual, the non-abusive parent, grandparent, kinship, guardian, next friend, adopting parent, or are we placing that child in a state agency, private agency, including the foster care system? This is important because it means that you can make SIJS findings in a divorce custody proceeding, in a paternity custody proceeding, in an order of protection custody proceeding. You also have to make finding that it's not in the child's best interest to return to their home country. And again, what you're looking at there is what's in the best interest of a child. If I'm made a determination that I'm placing the child with the mother, or I'm placing the child with the immigrant mother or with the immigrant father, and whether they're documented or not, if it's their intention to remain in this country and I've placed a child in that person's custody because I don't have the other parent, is not somebody I can place that child with, then that is a determination that that child's going to, that it's in the child's best interest to remain in this country with that parent.
Right, and so for example, what happens is if you go through and what judges typically do in a best interest is their statute says they have to consider both parents. Sometimes they'll say some statutes will allow them to consider grandparents, some, or other than that. And let's take an example where you have the child's father was sexually abused his teenage daughter in El Salvador in his mother's house, and his mother, her grandmother, did nothing. And so the court, in Judge Weir's context, would have potentially 3 potential caregivers: mom, dad, the perpetrator, and grandma, who's in El Salvador and allowed the abuse to happen. In that case, applying best interest, she could legitimately say under the best interest statutes of her state that it's in the best interest to be with mom, eliminate the other 2 caregivers, who are the only people who she has to consider as caregivers who happen to be in El Salvador. And once you've done that, it's not going to be the child's best interest to return to their home country if there's nobody who can safely care for them there.
And we also have to make the finding that reunification with of the child is not viable with one parent due to abuse, abandonment, or neglect. Now, I'll say that where I've seen most SIJS findings is either in default divorces where the other parent is gone. The other parent has abandoned the child. The other child, hasn't seen this parent for years, doesn't know this parent. That parent hasn't provided any support, emotional, physical, anything like that for the child. So I've seen them in divorce, and I've seen them in abuse and neglect proceedings.
And all these different types of scenarios could be an SIJS case. So it could be somebody, as I say, as Judge Weir is talking about, where the abuse, abandonment, or neglect happened in the home country or in the U.S., and these scenarios. And then there could also be a lot of different kinds of court proceedings. So the statute says it has to be a juvenile court, but the regulations make it clear by the inclusion of family courts here that juveniles mean all children, and it could be any type of a court proceeding where the court is making a custody or placement of a child.
Yeah, and let's say, it used to be that these primarily came out of children who were in foster care, correct?
Correct. There were a lot of child welfare proceedings, and they still can be child welfare proceedings.
Correct, but it was expanded.
Correct. It was expanded in 2008.
Right.
To include a variety of other different kinds of court cases, including the following list. So these cases, as you heard from Judge Weir, can happen in a variety of different kinds of cases. And in the bench book that we did on SIJS that is available, part of the materials that was sponsored by the State Justice Institute, there are chapters where a judge or sitting in any of these proceedings can pull out the 10-page quick reference guide on issuing SIJS in custody and support cases, and it gives you everything you need to do about the law from the context, from that perspective of what it looks like in a custody case versus a paternity, divorce, delinquency, dependency, et cetera. And there's chapters for all of those different kinds of relief.
And the thing here is that this is what state court judges, this is what we do all the time. We make determinations, who will be the custodian, where will the child live, or are we committing a child to, a state agency. So these are just things that we're doing, apply state law. I recently had a case, I was doing a divorce, it was a default divorce. I was asked to make SIJS findings, and it was an abandonment. And what did I do? Of course, I have jurisdiction over the child due to the UCCJEA, which defines abandonment. Also, there was my definition that I was able to use in making my SIJS findings. I applied my state law in our version. The UCCJEA defines abandonment. So again, always look to you want your court to always focus on their own state law. And
right.
Know that formal charges are not required. So don't get caught, don't get lost in that. You do not need formal charges to be filed in order to apply SIJS findings.
Right, so you don't have to have a formal juvenile delinquency or dependency proceeding. You don't have to have criminal charges. It could be just any other form of family law case where the judge is deciding custody or placement. What's also important here is that it's one or both parents. Sometimes for a long time courts were getting confused about this, but this was written like many parts of VAWA because we were seeing battered immigrants whose children were also abused. So if there's only one parent who's an abuser and they're being placed with the non-abusive parent, you can do SIJ orders in those cases just like anything else. We talked a little bit already about the best interest and how to approach the best interest factors. You can look at, you do that custody analysis that we talked about earlier, but there's also some other factors. Beyond the custody analysis, once you've decided, you may have a case where you could show that there's particular needs a child may have that are available in the U.S. to help them heal from trauma that aren't available in their home country. And we have a training handout that we can provide you on that. So in finding, anything else you wanted to say about reunification, Judge Weir?
Well, just that reunification doesn't mean never. So it doesn't mean that there's no possibility whatsoever that reunification with that other parent can ever happen. That's not what we mean. We mean, or what it means is viability is not, it's not viable that reunification with the parent is going to happen now. So you may have issues where there is some type of visitation, some type of supervised visitation going on, but that person's not going to be a custodial parent in the foreseeable future.
Right, and that's sufficient for finding non-viability. DHS is very clear they're not talking about termination of parental rights. And so I think what we'll need to do is, so basically it is, if there's some more materials that we can provide you, I'd like to potentially end on this SIJ slide, Judge Weir.
Where are we? Trying to get to it.
Best practice for court orders.
Okay, so yeah, this is what we want the courts to focus on, is making factual findings regarding what was the abuse, the abandonment, or the neglect. Just don't write that they were abused or abandoned. Give some details on that regarding each parent and what's going on, and cite your case law. Again, like I talked about in the abandonment case, I went to Missouri, UCCJEA definition of abandonment. Articulate the trauma, the impact on the child if you can. Connect the dots. Explain why the orders and the findings the court is issuing are needed for the protection of the child, for any trauma they've suffered, for the healing, any programs that they're involved in, that they've been involved in school, how the children are doing here, and then why the court finds this order is in the best interest of the child.
So I want to thank you for joining us today. There are resources available that we'll make available. We'll send a follow-up email to the resources we've talked about here and materials. And I'm going to turn it over to Rosie Hidalgo to close out.
Great. Thank you so much, Leslie and Judge Weir. That was a wonderful webinar with a lot of really important information. And as both Leslie and Judge Weir pointed out, many times abusers count on misinformation, count on an immigrant victim not knowing her rights. So this is where it's so critical for you all as advocates, attorneys, people in the community in many different ways to make sure that immigrant survivors know that there are important protections, that there are services for them. So we will be sending the link to this webinar along with the resources that have been mentioned. We encourage you to share this webinar link with others in your court system, in your community, who could benefit from learning this information, so that we can make sure that immigrant survivors have access to safety and justice, and so that they know that Congress, in a bipartisan fashion, created these remedies, wanting to make sure that immigrant victims can have this access. So again, thank you for participating, and we want to remind you that next week, Monday, October 22nd, at the same time, 12 o'clock Central Time, 1 p.m. Eastern Time, we will be having part 2 of this webinar. And next Monday, we're going to focus on important VAWA confidentiality provisions and talk about how do those confidentiality provisions play out in court proceedings and in other sensitive locations for immigrant survivors. So if you have not done so already, we encourage you to sign up for part 2 of the webinar for next Monday and to share that information with others in your community who could benefit from it. So again, Leslie and Judge Weir, thank you so very much for all the information, but also for the tremendous work you all do every day. And thanks to everyone for participating. Take care.
All right,
bye.